Friends, now moving on to understanding another type of special contracts that has been covered in the Indian Contract Act 1872 and which in current times, in contemporary contracts, assumes a great amount of significance uh, in terms of, say, having a clause in a contract or trying to cover the losses through such contracts, and that's called indemnity contracts. Now, indemnity contract is a special category of contract, and it is covered with indemnity and guarantee, as it is called. And to be honest, if you look at the Indian Contract Act, it has only two sections that are dedicated to trying to define and understand indemnity. And the courts have rightly said that these two sections don't entirely state what the law of indemnity is, and you can actually infer the law of indemnity in several other provisions of the Indian Contract Act itself, and with reading of other sections of the law, like the Companies Act. Can directors claim indemnity from the company? So you can look at the Companies Act. Can partners claim indemnity from the firm? You can look at Partnership Act. So there are numerous instances of this indemnity that exist, and hence to understand what indemnity is, you will notice is that again there are two parties to this contract. One is called the indemnity holder, who has the promise to be indemnified, and one is called the indemnifier, who has the responsibility to indemnify. So, interestingly, the aspect of indemnity to indemnify means to do what? In the UK, these clauses are called the hold harmless clause. Hold harmless clause. That's how the UK law, the common law, looks at it. And to indemnify means to say to the other person, look, I will cover your losses. I will cover your back. Don't worry. Be there, do the contract. If anything happens to you from this relationship that we have, the contractual obligation that we have, if you suffer any loss, then it is my duty to compensate you for the same. So that is what it means to come up with a promise of indemnity, which means that you do not want your contracting partner or your contracting party to suffer any kind of a loss that arises from the contract itself or may arise from your actions, as the case may be. And hence, in modern commercial contracts, not modern, even quite from early times, I think one of the most essential negotiated clauses in most modern day contracts is the clause of indemnity. As I told you in the past, while discussing about Section 27 and Section 23, today an employment bond is also titled as an indemnity bond. So you expect the employee to indemnify the employer in case he forfeits the term of the contract or leaves the term of the contract before the time stipulated for any kind of loss that may arise from his leaving of the employment. That is what indemnity actually means, right? So the essentials of indemnity, friends, are that, look, when you get into such a contract or such a clause in a contract, you anticipate that there can be loss that one of the parties to the contract may suffer or both the parties may suffer. To be honest, in modern context, you will notice that indemnity, if you look at the law and the broader context of the same, it is usually mutual. It cannot be just one party promising the other. It has to be also the other party saying, in case I commit the loss, I will compensate. If you commit, you compensate. So it is based on what we call as the mutuality principle. Both have to have an implied obligation to indemnify the other. Expressed, probably the division of responsibility can be divided. So there is this anticipation that the other party may suffer some kind of a loss, and you already have a contract. And your intention when you agree to the indemnity clause is that you want to save the other party from any such losses. And in good faith, when you do the same, whether there is an express or an implied contract doesn't matter. You actually have a duty to indemnify. Right? So that's how the contract of indemnity plays a very, very important and a critical role in today's context. Moving forward, what does indemnity do? It actually promises the other to save from the loss that is caused by his own actions. Okay, that is when you strictly read Section 124. So, from the act of the promisor or any other individual. That's where Section 124 is only about such kind of losses that may be caused just by the contracting party's behavior, conduct, or its contractual relationship. However, indemnity is far broader than that, because notice that you may suffer loss because of not only my fault. You may suffer loss in this contract because of natural factors, and natural factors could be a cyclone, an earthquake, a volcano, a tsunami, a flood, so on and so forth. So there again, you talk about saying, look, once you enter into a contract and in case you suffer losses from these natural factors, then I will compensate you. Don't worry, please go ahead and fulfill your obligations in this contract. So that could be also a kind of a loss that needs coverage, that needs some kind of anticipation to be factored into as well. Also, you will find that losses can be caused due to accidents, right? So when someone is producing some machinery for you, or you're handling someone else's machinery, the machinery can meet with an accident, and then you expect the manufacturer to say, look, in case while operating this machinery you suffer any kind of a loss, or is there an accident that occurs due to the handling of this machinery, I will compensate you, I will indemnify you. So have the confidence, by this machinery, right? So the indemnity clause is usually used as a guarantee to the performance of a product. It is also used to give confidence to the other party, saying that don't worry, I think I'm there. Any kind of loss will be covered due to my inactions. And accidents usually are not necessarily that can be caused necessarily by human or natural factors. It can be simply a patent or a latent defect in the machinery itself, right? So it's not necessarily a human error or a human factor that has to be taken into consideration. And those accidents are also something that indemnity may want to cover in the long distance. So it has some very, very important, significant implication to how contracts are actually taken into anticipation. How do you look at the different kinds of indemnity in India and abroad? I think there are different kinds of indemnity that are very, very important. For example, intellectual property indemnification is the most popular one, IP indemnification as it's called. This is a case where a patent holder or a patent kind of technology inventor or a manufacturer, he says that, look, you buy this product. I'm giving you the license to this product because I have the IP to it. Tomorrow, if someone else's files an infringement suit against you, then you have to defend it and you suffer any kind of a loss because of that infringement suit, I will promise to indemnify you for that kind of a loss or that kind of a hardship that you actually undergo because you have taken an IP license from me. So that is usually kind of a promise that holders of intellectual property get into, and that is how an IP indemnification clause makes that kind of a promise. Product indemnity is based on the same example that I told you, that I want you to take my product in the confidence that if while handling that product anything happens to you or your employees or any other person, I will cover that loss, I will cover the risk, I will indemnify them. So that's what a product indemnity would also mean. Similarly, professional indemnity. Now, this is interesting because you want professional indemnity to be there when, suppose I am sending one of my employees to do some on-site work, and due to his actions or inactions, you suffer any kind of a loss or injury due to his professional misconduct or otherwise. Then, in those cases, I have to give you that assurance, saying that, look, don't worry, allow my employees to come on site. If anything they do due to which you suffer any loss, I will compensate you for the same. That's an assurance, that's a promise that usually in professional indemnity people give. So you will again see the dimensions of indemnity and the applications of the same that are required as kind of a risk assessment in modern kinds of contract that have to be generally undertaken, and these have to be negotiated and agreed upon, though there are different forms that are available on these kinds of indemnity clauses. This is basically how people design contracts in the modern context, and this plays a very, very important role in government contracts. Indemnity has a very, very important obligation to be completed as well, because you don't want contractors just to be giving you basic nominal damage or compensation, which is how the law on damages works. So if one views why indemnity is important, is because indemnity is far broader in its application and scope than what damages is. So most government contracts have damages clause, but they forget to have an indemnity clause. Now, damages clause, friends, the limitation of damages is because of the fact that under section 73 and 74 of the Indian Contract Act, you are entitled to only those kinds of damages that are reasonable in nature. So in India, we do not have any kind of damage that says you can get exemplary damage. You get only nominal damage, right? Point one. Point two is there is something called the rule of remoteness of damages, which means you cannot get damage that is remote. Damages that can be foreseen, damages that are direct, are only things that you can actually get as monetary quantification of the loss that you've suffered. So damages has certain limitation, damages has certain restriction, it has a huge jurisprudence of what you can claim and what you cannot claim. However, indemnity, friends, the very idea of indemnity is to broaden the liability of the other party to cover things that you may not have foreseen, things that maybe due to the action of third parties, things about something that is indirect, something that is consequential. So indemnity's basic purpose is to expound the whole law of damages, which has a huge limitation to what can be claimed and what can be asked. Indemnity actually is used to actually broaden the same, and hence it becomes a very, very important and innovative part of contractual discussion. Very often than not, insurance contracts have been called as indemnity contracts. They are in one sense, but they're not ones that are covered under 124. They're covered under the broad ambit of indemnity, because the basic duty of insurance company is to cover your loss. So you pay premium, you hope nothing will happen, but if something happens, the insurance companies comes and holds you harmless, which means that, not in the sense of a criminal conduct. So there's nothing like indemnity, but the civil liability, the insurance companies definitely will say, look, we will compensate you the money, and that loss is definitely covered by money. So don't worry, don't have any hesitation. Please go ahead with your business. So fire insurance could be indemnity insurance, and so on and so forth. So most companies take some of these insurance, which are critical and important as well. Also, you will notice that today doctors take what we call as professional indemnity insurance. Why is this important? Is because, see, doctors can be sued for negligence, medical negligence, right, from the patients. And very often than not, if the doctors have to pay compensation for medical negligence, then the professional indemnity insurance can be invoked, and the insurance company will pay the patient that kind of compensation. The doctor need not pay from his own pocket. So that's the kind of job or the responsibility that these professional indemnity insurance do, right? So that is something that a lot of professionals take, including directors of a company, because today directors are unfortunately going to be held personally accountable or liable. They inevitably want to cover that risk or transfer the risk with an insurance company. And even directors of companies do take what we call as the professional indemnity insurance. So if the director is personally sued by a shareholder or by any kind of an individual to which the director has to contribute or pay, though whatever has been sued is in a professional capacity, not in his official capacity, then the director will end up paying a lot of money, and hence the insurance works in his favor, right? So the insurance company will step in, like it does in case of doctors, and it will actually pay that kind of an indemnity to those third parties as well. Also, interestingly, in indemnity, there is no limitation of liability unless you want to cap it and you say, okay, for example, in insurance, we say, right, fire insurance is great, I will do it, but my final responsibility is just 10 lakhs or 10 crores, right? So that's the final limit that insurance companies will actually give you. So it's not unlimited every sense of the term, like whatever your loss, we will cover it. No, it is some kind of a cap that usually comes into place. For example, we talked about indemnity bond in employment. It's not unlimited, so it could be 3 lakhs or 5 lakhs. So that is what your indemnity liability is. So you could have that kind of limitation of liability. That is definitely possible in terms of the amount and figure that to which you should be held accountable to. At the same time, please note, indemnity can be quite broad in terms of third-party losses and liabilities, in terms of those that are foreseen, in terms of those that are consequential losses or damages. And consequential is something that in most common law jurisdictions is not admitted, whereas indemnity can actually help you gain those kinds of necessity losses as well. Finally, if you go by implied indemnity, I think it's very important to understand that in common law, and I think, if you look at how the courts in India have always viewed this provision, they say that, look, every contract is a contract of good faith. right? It may not be of utmost good faith because insurance contracts are considered to be contracts of utmost good faith, but every normal contract is a contract of good faith, which means that due to the contracting party's own fault, they should not create a loss to the other party. Right? This is something that is implied by the laws of obligation. If there is any such loss, then you have a duty to indemnify the other person. Normally, we'll say for that loss you will have to pay damages, but indemnity is also about the fact that look, you are going to be held accountable, you're going to be held liable, and this is implied in law, implied in contracts. So you cannot, from your promise obligation or from your contractual obligation, cause any loss or damage to the other party in the contract. So implied indemnity has been in existence for quite some time, and we know that in most cases where contract comes into existence, the party that causes harm promises to hold the other party harmless, and any kind of harm has to be compensated, equated in terms of the monetary loss or value, and everyone has a right to claim the same, irrespective of whether the law defines it or irrespective of the fact that the contract has such a clause. Right? So that's the general nature of indemnity in the form of damages that ought to be always paid or covered, and that loss is something that needs to be compensated as